appearing via WebEx, the jury and also not present. I received the following communication, which I have shared with counsel. Please confirm if on page 51 of your 7/7/23 sentencing order, line 19 and 20, your reference to special circumstances, plural, refers to financial gain and line and weight, People's Exhibit 276. So I have People's 276 in front of me, which, by the way, was originally a two-sided page. Every other page is missing from this. For example, I have page 1, page 3, page 5, etc. But going to page 51, lines 19 and 20. It says, for the crimes which the defendant has been convicted, in count 1, murder in the first degree, in violation of section 187, subsection A, with the special circumstances, plural, having been found true, it will be the judgment sentence of the court as follows. And then I went and imposed judgment. The defendant, or the former defendant, Baker, pled straight up. I took the plea myself. I took independent admissions of each special circumstance. And I'll hear from counsel in a moment. And my proffered answer is yes. It refers to financial gain and line and weight special circumstance. And I'll hear any objection.
Yes, Your Honor. The basis of my argument to the jury was the transcript that was marked and sent back to the jury, and also basically what Mr. Baker was told at the time of the entry of his plea. The point was that he would not have entered a plea by the conspiracy with Monica Sementilli, which was contained in the indictment, but was not read either by the court or by Ms. Silverman when she took the waivers and said, this is what you're pleading. And the point was not that Mr. Baker's sentence is not in question. It's not as if he's arguing on appeal that there were no special circumstances that he pled to, therefore the plea's invalid or anything. This was all based on what was said to him in open court and why he agreed to the plea. He could have not agreed to plead open. And it was our argument, had it said conspiracy with Monica Sementilli, he would not have pled open, and only pled open to what is in the transcript. So I would ask the court to just refer the jury to the transcript. It's not a question of what the court intended, because Mr. Baker got what the court intended. It was what was an impact of the words to Mr. Baker when he chose to enter.
That is not what the question was. The question was relating to my words when I did the sentencing. When I referred to the special circumstances, was I referring to financial gain and line and weight? And that's exactly what I was referring to.
But if he's pleading special circumstances, it doesn't matter what they are. He still gets life without parole. So it didn't, right. The court either should have said, with all respect, read them, or understood that as long as he's pleading the special circumstances, frankly, it doesn't have to be two, it only has to be one, I believe.
Except it was two.
It was
and
two
I said that in the plural.
It was two, fine, and so he pled the two special circumstances, and he understood that, but it was not read to him. That was my only point, and the court didn't read, why didn't the court read the letter of the indictment, which was Monica Sementilli, conspiracy to commit murder with Monica Sementilli. That was not read either. It's my belief that he would, if had it been read, he would not have agreed to enter the plea, which was his.
Again, that's not relevant. What is relevant is what
was relevant to my argument to the jury.
But he pled to me, and he pled to me, admitted each individual special circumstance that was charged, and I sentenced them to the murder with special circumstances.
All right, I'll just make my point.
Okay.
It's not what the court, this trial is not what the court meant in the Baker sentencing. That's my point. I know what the court meant, and if there was an issue of the sentencing of Baker, the only point to even get into the transcript in this trial was that those words were not said and Mr. Baker was not admitting to those in front of the court and the jury, court, and we don't know what he would have done if the court had read Monica Sementilli and so forth, and I believe his statement that she was never involved was meant to, when he pled, not to incriminate her in any way. Her name's not mentioned. I don't see why the court can't just refer them to the transcript, because the court's intent in sentencing Mr. Baker is not an issue in this case.
I understand that, but that was not the question.
And Your Honor, if I just may add one
All right.
brief point. I believe the juror's question is asking for Your Honor's state of mind in your reference to the special circumstance referred to in the transcript. And respectfully, we do not believe it would be appropriate for you to give your state of mind, your intended reference to which special circumstance in response to this question, other than just indicating that was what was said by the court to Mr. Baker.
On page 51.
That is not what was the question that was asked, and it wasn't asked to my state of mind. But I appreciate that. Your record is made. Do people have anything that they wish to say, Ms. Silverman? Ms. Silverman,
Judge, that was why I objected during the argument. I didn't take the plea. You did. So I think that their question is exactly what the court has indicated for the record.
Okay, thank you. I am going to do my original answer.
Yes, the answer is yes.
Over objection, obviously.
Actually, the question, and it is over your objection, it won't be yes, it will be confirmed. Please confirm if on page 51, et cetera, et cetera.
Yes.
Please confirm. The answer which should be yes. If you're going to answer it, then it's positive. Not, I don't think you're confirming anything. You're answering yes as to what you. Well,
I understand.
I've made the point.
And you did very well too. Thank you. You just sent back along with the exhibit. Whoops, the exhibit fell apart. All counsel are present with Ms. Silverman on the WebEx. All other counsel in court for the defense. Jury and officer not present. Mr. Levine?
Your Honor, the additional point I realize that I think is relevant to the court's tentative ruling is that I was operating, when I was arguing to the jury, with the transcript that was in evidence. If the transcript that was in evidence, and which the jury got, had said financial gain and lying in wait, I would have argued to the jury, and I think accurately, well, Mr. Baker did not object to that because he was lying in wait, and he got some financial gain, or intended to get some financial gain himself from out of this, whether it was marrying, having her to himself, or however. Because many of the statements that we put in the record from Mr. Austin, for instance, had to do with her. She's coming into money, she's rich, she's got a lot of money, and so forth. My point was differentiating between what Mr. Baker pled to and any inference that he was admitting the guilt of Monica Sementilli, which he says he was not. If that had said lying in wait, special circumstance, and financial gain, I would have said, now there's no problem with that. Neither one of those necessarily involved with Sementilli. Although the conspiracy with Sementilli was an issue, and that was not included. That was my point, and I was deprived of that because I didn't have to respond to something because it wasn't there.
Now, you found just today that you were surprised that every other page was missing. You said, is this page missing? That page? Yeah,
well,
you didn't know it. I got the impression you thought it was a complete transcript.
At the time, we all assumed, I think, the exhibit. But that's what was in front of us. That's what was marked.
Well, that doesn't change my ruling.
That came from somewhat from the prosecution or from the court. We didn't make up the transcript, Your Honor.
So that doesn't change my ruling, but thank you.
Well,
all right.
Very well.
Thank you all.
Thank you. Thank you for the additional time.